on the ground that the records are displayed. Kindly see the was extended from time to time. A gazette notification was issued to your lordship may kindly see. At page 239, you are 242, 239. Type copy. For the grant of land.
Yes.
The fact of my filing the application is recorded in the land tribunal order. My application has been acknowledged by the tribunal. Your lordship may kindly turn to page 237, the order of the tribunal. Their contention was I never filed an application. I filed an impleading application. That impleading application doesn't give a right. It's totally wrong. Two 237, your lordship may kindly, I'll only read relevant paragraph. 237, page 237. Your lordship, before the order is passed, a discussion in respect of each of the applicant. Finding an application was made by me, contrary to the submissions at the other side, no application was made at all. The prescribed time limit for making an application for a grant of occupancy right under section 10(3) of the Mysore Personal Inam Abolition Act is 31/12/1979. Therefore, we can safely come to the conclusion that application is barred by limitation. One of the grounds for rejecting my application is time barred by limitation. As I made submission, the state amended that rule frequently, and the last amendment was done on 2021. Which extended the time till the end of 2022. The Inam Abolition Act, Rule 7. Was amended by the Act. Your lordship may kindly see the Act. Application was in fact the question of May thing. Now, the next question that arises for the consideration is the view of section 3F, as pointed out, 3F obliterates every right accrued to that, section 64 and section 40. Now, Your Honor, kindly see. May I take your lordship to 3F? 64. No such your lordship has been able to say. Section 3F of the Inam Abolition Act. This is what has been highlighted and argued by the other side vehemently, saying that I don't have the right.
Section 3.
3F. Section 3F, your lordship. If after vesting, what happens in the consequences of vesting of the Inam in the state is the 3F. they highlight it and say I am debarred to make an application. No such inam shall be liable to attachment or sale in execution is subordinate to section 73. Subject to section 73 means this dominates, that other one becomes a subservient to that. '73, your lordship may find this. Right to proceeds of revenue, sale or compensation on acquisition, where the property, where the mortgage property or any part thereof or any interest therein is sold owing to failure to pay arrears of revenue or other charges of a public nature or rent due in respect of such property, and such failure did not arise from any default of the mortgage, the mortgagee shall be entitled to pay payment of the mortgage money in whole or in part out of the surplus, the sale proceeds remaining after the payment of arrears of all charges and deductions directed. So it contemplates that certain actions, despite PF is protected. PF does not obliterate all the acts. Now, your lordship is 14 also. These reading of these. DC 3F again once for, I mean, I'll take your lordship to 3F. DC 3F again once for, I mean, I'll take your lordship to 3F again. 3F says, your lordship, no such inam shall learn liable to be attachment or sale in execution of any decree or other process in a court. Any attachment, your lordship can see. The word is it existing on the date of it. That's a past act, not the future. Section 3F speaks of past acts, not the future acts. There is no bar for the inamdar to encumber the property after the notification because it is not in parametry of section 4 of the Land Acquisition Act. This 3F contemplates the prohibition, alienation, disabling or the attachment shall cease to exist. So, your lordship can see there are two ways that can be looked into. Cease to means it never gets dissolved from the date when it is granted. Cease to effect from the date on which it is act came into force. While learned friend argued that gets dissolved. The word dissolved is not used. It's only in the Land Reforms Act the word dissolved is used. Under section 133, your lordship may kindly see of the Land Reforms Act. The legislative order saying that any injunction order that is prevailing on that day shall stand dissolved, as if it never existed. Here the language is it ceased to exist. If it ceased to exist, it never dissolved it. It started operating, stopped operating from the date when the notification came. So there was no embargo placed under the 3F that inam land shall not be encumbered after the Abolition Act came into force. Now, the next question that now let me take you to the provision of section 64 of the CPC, my lord. CPC 64 is an inclusive, exclusive definition, section 64 of CPC. Section 64, where 1959. The sale that has taken place, your lordship may kindly see, between 53 and 59, the attachment was enforced. 53, his sale is on 20th June 1956. The sale in favor of him when the attachment was subsisting. Now, what is the effect of attachment? Your lordship may kindly see. The effect of attachment before judgment under section 64 is the possession of the property passes on to the civil. nobody can, even including the owner, can't meddle with the property. I have cited one authority before the trial court also in 1961. Supreme Court 271. I pass on this. It has been referred to in the impugned judgment. The effect of attachment. Now, make I take your lordship and para 12. And later, the decision rendered in the next page, your lordship will kindly see. Therefore, the next page, your lordship.
Therefore, which paragraph?
The effect of the attachment as presented is been called out. Therefore, your lordship got it. Para 12. Para 12 continuation of it there. The judgment of the other case is cited, called out there. Next page. Therefore, when a property has been attached under an order, your lordship will be able to read it. Under an order under section 379 of the Indian Penal Code, if you knew that the property had been attached in the bonus. So, since the property was attached when allegedly he purchased the property, the possession was with the court. He could not have taken possession of the property. If we say that he has taken possession and has given Kaveri had given possession, it attracts the penal consequences. Para 13, your lordship of kindness. We need not multiply decisions as the legal position is clear and it may be stated as follows. Where a property has been legally attached by a court, the possession of the same passes from the owner to the court or its agent. In that situation, the owner of the said property cannot take the law into his own hands, but can file a claim petition to enforce his right. If he resorts to force to get back his property, he acts unlawfully, and by taking the property from legal possession of the court or its agent, he is causing wrongful acts unlawfully, and by taking the property from legal possession of the court or its agent,